Welcome to this free trial podcast presented on behalf of the Royal Faculty of Procurators in Glasgow and jointly with the Scottish Law Agents Society, that's RFPG for the faculty and SLAS for SLAS. These institutions jointly present the Trainees Continuing Professional Development Programme, TCPD, which is required by the Law Society to be undertaken by all trainee solicitors. I am sorry about all the acronyms, but I'm afraid that's the world which we live in. My name is Michael Sheridan and I am the convener of the Trainees Continuing Professional Development Programme on behalf of the Royal Faculty and the Law Agents Society. The purpose of this podcast is to introduce you to our training programme, but also to present trainee solicitors with some free TCPD material and even qualified solicitors with some free CPD material. Now, in order to qualify this material for recognition by the Law Society for TCPD and CPD purposes, we require to have a means of verification of attendance. Therefore, if you wish to undertake this podcast for these purposes, then you should now, at this point in time, send an email to secretary@slas.co.uk. The subject matter will be TCPD or CPD as the case may be, free trial podcast, and the content should be the name of your firm if you are with a firm, and the date of your graduation if you are a law graduate, or of your commencement of traineeship if you are a trainee solicitor, or the date of your qualification as a solicitor if you're already qualified, stating only the latest of these dates and advising which one applies, of course. Now you should now pause this presentation while you send that email, and of course our receipt of your email will verify your commencement of the podcast. Now note that the subject matter of the podcast is the regulation of the solicitor's profession, which you will find is a subject of very much current discussion, speculation and even controversy. We will first of all consider a timeline showing the main events in the development of the regulation of the solicitor's profession. We will start the story in 1873 when Parliament passed the Law Agents Act of that year, the expression solicitor not yet being in use in Scotland, and this act made the passing of examinations a requirement for the admission to practice as a law agent. This was in addition to the long-standing existing requirement to undertake an apprenticeship, what we would nowadays call a traineeship. The requirement to pass an examination greatly increased the status of the law agent. Otherwise, the position before 1884 was that law agents, as they were then known, were regulated to some extent by the local faculties and associations, such as the Royal Faculty of Procurators in Glasgow, whose history goes back more than years than anyone actually knows, WS Society in Edinburgh, the Society of Advocates in Aberdeen, and many others. With no disrespect to any of these societies or associations, I'm not mentioning all their names at this stage. At the last count, there were about 28 such societies and associations around Scotland. However, there was no national body for solicitors. In 1884, the solicitors themselves applied for and received a royal charter from Queen Victoria, and this established the Scottish Law Agents Society in that year. This was the first national body for law agents or solicitors in Scotland, and this body was formed in order to provide for regulation of education, training, and also to give a means for establishing professional standards and discipline, and to provide the profession with a voice in which to address Parliament and the government and whoever else was interested on these issues. Of course, SLAS was well aware that these lofty ideals would not be worth anything unless there was legal compulsion to enforce the regulatory aspirations. As early as 1903 and possibly earlier, the SLAS Council drafted a Solicitors Scotland Bill to make membership compulsory, and in 1933 a first step was taken in that direction with the passing of the Solicitors Scotland Act of that year. That Act created a Council of Solicitors to direct the regulation, education, training and discipline of law agents, and to give that profession its new title of solicitors. You should watch very carefully in the rest of this presentation to see what actually became of that Council of Solicitors. In 1949, the SLAS project of creating a compulsory law society under the legal control of a Council of Solicitors was realised, always subject to direction and supervision by the Lord President. At that point, the main aspiration of SLAS had been achieved, and SLAS might well have faded out of existence. However, when we see what came to happen or what developments took place when the regulation of solicitors was under parliamentary control, it seems that it was just as well that SLAS did not fade out of existence. By 1980, the high point of the regulation of the solicitor's profession by the solicitor's profession was achieved in terms of the Solicitors Scotland Act of that year, under which the Council of Solicitors presided over the whole gamut of education and training, discipline, and also over the important function of providing public access to justice through the legal aid system. However, in 1986, a new legislative direction was established when the administration of legal aid was removed from the Law Society and placed in the hands of the Scottish Legal Aid Board, a new government agency created for that purpose. This was very much a foreshadow of things to come. In 2007, the fundamental responsibility for professional discipline was transferred from the Law Society to another new government agency, the Scottish Legal Complaints Commission. However, that transfer was not complete, and there was some doubt in terms of the legislation just where the Law Society responsibility ended and the SLCC responsibility began. Now, that uncertainty led to litigation. In fact, it led to some 20 actions in the Court of Session between the Law Society and the SLCC. Now, the strange thing about that legislation was that it was the solicitor's profession who funded both sides of all of these actions. Now, it seems pretty strange when a group of people would sue themselves even once, but to sue yourselves 20 times in the Court of Session does seem a little bit excessive. And you'll understand now what I was saying earlier, that in some respects the regulation of the legal profession is a somewhat controversial topic. Now, the new statutory direction was carried on by the Legal Services Scotland Act of 2010, which effectively removed the regulatory function from the Council of Solicitors. I told you to look out for that, and was transferred to a new regulatory committee. Now, that committee, although it exists within the Law Society, solicitors are statutorily excluded from the chair. You can't be chair if you're a solicitor, and also from the majority. There cannot be a majority of solicitors. This means that rather than having responsibility and control of the regulation of solicitors' profession, solicitors themselves are actually legally excluded from that control and responsibility. This is another reason why I suggested earlier in the presentation that the current regime for the regulation of the solicitor's profession is somewhat controversial. Now, that controversy was at least potentially deepened by the contents of two reports commissioned during 2018-2019 by the Scottish Government. I say potentially deepened because it's not entirely clear that anyone has shown a great deal of interest in these developments. Perhaps it's because we're all distracted by Brexit, of course. Also, perhaps people do not believe that what has been proposed could ever actually happen. What has been proposed is the abolition of the Law Society as a regulator and its replacement by yet another government agency, an independent regulator of legal services in Scotland, and the removal also of the Lord President from his supervisory role and his replacement by the Scottish Parliament. I'm not clear why anyone should doubt that this all may well come to pass, because after all we have already seen the removal of Law Society responsibilities and its transfer to new government agencies, the Scottish Legal Aid Board and the Scottish Legal Complaints Commission. And the setting up of this new independent regulator would simply be another logical step along the same line. And we'll just now note the report, the two reports I was talking about. One was Esther Robertson's independent review, and the second one is a report by the Competition and Marketing Authority, both of which propose these changes to remove the Law Society and the Lord President. Just in passing, I should mention that it's an interesting view of this, that what we see is the legislative, the Parliament, removing a function of the judiciary, the Lord President, and that would raise interesting issues, appear to raise interesting issues in the context of the separation of powers, where the legislature and the judiciary should be separate powers. Now, that brings us to the present day, when we now have to consider what may lie in the future. It seems that the regulation of the solicitor's profession will be imposed upon that profession rather than operated by the profession itself as it was previously. If this is to be the case, then the solicitor's profession seems to find itself back in the same position as it was in 1884, with no national body of its own. It may be appropriate, therefore, to consider the revival of the solicitor's own body, the Scottish Law Agents Society, SLAS, which, as I say, never faded out of existence, or to take some other means to ensure that the solicitor's profession has its own national body in order to find out what is the profession's view on issues and to represent that view to relevant bodies such as Parliament and the Government, and in general to ensure that the solicitors themselves have their own voice in these matters. Now, a quick look, and I say a quick look at the regulatory scheme, because this is a very dense picture we have now. A quick look at the regulatory scheme, roughly as it exists today, because you can see that the Law Society of Scotland has a regulatory function. You can see the supervision of the Lord President of the Court of Session. Now, if we just quickly turn to the situation that will prevail after these changes take place, you see the removal of the Law Society and or its banishment to the bottom line with an unclear function, and at the top of the tree, the supervisory function of the Scottish Parliament. Now, despite what seems to be a somewhat complicated and contradictory statutory position, and this, we now come to the crux of this presentation, there is no doubt that the current position today is that the legal profession is regulated by the Law Society of Scotland. There is no suggestion from any direction that that regulation is anything but entirely successful and appropriate, and indeed it provides a great service to the profession and to the public served by that profession. In particular, the Law Society in 2011 produced a statement of practice rules, and subject to some amendments, these practice rules remain a clear statement of the requirements of professional regulation, and every solicitor should be closely familiar with these practice rules, and we're going to start that familiarity here and now. At this stage, you should note down these details. You go to the Law Society of Scotland homepage, go to Rules and Guidance, go to Section B, Fundamental Principles of Client Care, and go to Section B1, Standards of Conduct. Now, in order to complete your undertaking of this podcast, you require to study these standards of conduct. They're written in reasonably clear and plain English, and we now have sight of them, but rather too small to read, I suspect, so we'll just look at them individually. Trust and personal integrity, and that applies whether in the professional capacity or otherwise. So being a solicitor is more than just a job or a vocation. It's a way of life. It's your personal life must also be is subject to trust and integrity. Independence. The solicitor must act independently and be prepared to stand up and say things, for example, in court, even if the sheriff doesn't want to hear them, and that sometimes happens, I can assure you, but you've got to speak boldly and independently on behalf of your client. You've got to attend to the interests of the client. Even if the sheriff doesn't like what you say, that should have gone to the previous slide. The interests of the client, you have to ensure that you observe your client's interests, even if they conflict with your own interests, even, for example, if they conflict with the policy of the firm that you work for. It may be difficult, but you do have to put your client's interests first. You have to take proper instructions. Instructions must be proper. For example, you cannot collude with your client to hide criminality. The duty to be honest and applies throughout your work, and you can't hide evidence or collude with your client to hide criminality. The duty of confidentiality. I like to sum that up by observing that a client's information is something like the client's money. You don't use it for your own purposes, that's obvious, but you come into possession of both of these things. You'll hold clients' money, you'll hold clients' information. They're not for your benefit, obviously. It's perhaps less obvious in the case of information, but it's the same duty. It's not yours. Conflict of interest. You don't act for opposing interests. You avoid acting even for potentially opposing interests, even if there doesn't appear to be any conflict. For example, you might act for a landlord and a tenant who are both in agreement with each other, so you can act for both of them if they're both in agreement, but there's a potential that they might come into conflict with each other, and so you shouldn't act for both. Disclosure of interest. If there is any possible conflict of interest with another person, then you have to tell your client about it and make sure that your client's willing to instruct you, even if there is some potential, remotely potential conflict of interest. You must have effective communication with your client throughout the instruction. An example of that would be you must keep your client aware of ongoing costs There's no point in building up a huge bill that's going to come as a serious shock to the client. You must keep them informed of ongoing costs. You must provide competence, diligence and appropriate skills. You might, for example, need to seek advice when that's required. You might, on some occasions in complex situations, you might want to obtain counsel's opinion. Professional fees, of course, these must always be fair and reasonable and as far as possible in line with quotations provided. Withdrawing from acting, that's always a delicate matter when you feel you can no longer act for a particular client. You cannot withdraw from acting unless there's just cause and you give reasonable notice. Relations with the courts, bear in mind a solicitor acting in court is an officer of the court. He cannot mislead the court and they cannot defy the court, because as well as being the solicitor to the client, you're an officer to the court. Relations with regulated persons, this phrase is slightly puzzling. What's a regulated person? For present purposes, just regard that as other solicitors, and there must be a relationship of trust and confidence between solicitors. And if a solicitor acts in such a way as to break down that relationship, then that's a serious matter and it's something that can be reported to the Law Society and bring about professional discipline. And lastly, diversity. Obviously, you must have no improper discrimination either towards your clients or towards people working in your office or anybody coming into contact with. So that brings us to the conclusion. You can now pause the presentation to study this slide. In order to complete the podcast, you have to consider those standards that we've just gone through. You have to decide what you think are the 3 most important standards and write a short essay of at least 750 words to justify that, and then you email that essay to the email address given. The subject matter will be free trial podcast essay. That's to arrive within 7 days. After that time limit it won't count. If it comes within 7 days of the date of your initial email, then it will count for CPD or TCPD purposes. You should also make a note of how long you spent writing the essay. That will help to determine how much time you will be credited as having worked towards TCPD or CPD. So that really brings us to the end of this free trial podcast. If you will, as I say, send this short essay, or longer if you prefer, you can make it more credit. Send it to us. It must come within 7 days of the date of your initial email, otherwise we can't credit you as having undertaken the podcast. Thank you very much for your interest.